So, what are my qualifications for debating a Dean of Law on constitutional law? I was brought up with Rumpole of the Bailey, and I watch Suits. Those are my two main qualifications. But I've been in a number of debates on this topic, and it's generally an unfair debate because I'm armed with the unfair advantage of ethical and moral realities being on my side. I have all of the valid evidence on my side, facts and data on my side, and not to mention the law. But I'm just one of a group that included 6 patients fighting against unjust Canadian laws that are literally causing illness, suffering, and death in the Canadian population. It was in 1994 that the Canadian Bar Association published this book, which you see illustrated, and it accurately predicted the role of the law in reforming healthcare. The answer to the title question, what's the law got to do with it, is everything. Lorne will oppose my opinion, but as a Dean of Law, he should be proud of the role his colleagues will play in Canadian healthcare reform. The last time I was scheduled, and I too would like to acknowledge Lorne's bravery in tackling this debate. The last time I was scheduled to debate with a Dean of Law on this topic was about 20 years ago on a live CBC debate. Andrew Petter, who's now a university president, was a Dean of Law, and at the time of the scheduled debate, he was the Minister of Health in British Columbia. He withdrew at a day's notice from the debate because he had not been adequately briefed to debate health law with an orthopedic surgeon.
Remarks by saying I was originally scheduled to debate these issues with Andrew Petter, who declined to come on.
Mr. Petter, by the way, I remind our viewers in the other 9 provinces, of course, is the health minister for BC. We got our rapid results, or rapid response results. We do. In response to the question, do private health clinics threaten Medicare? 27% of you said yes. 73% of you said no. There you go. We are done.
So that was a CBC audience, and you can probably imagine they're not necessarily to the right of center. But I think it's important for us to recognize that history includes a legacy of laws that were unethical, immoral, and illegal. As such laws allowed slavery, apartheid, racial and sexual discrimination. Laws existed in my lifetime that declared homosexuality and suicide illegal. I also include in that category laws with Orwellian names, like in BC, the Medicare Protection Act, and in Ontario, the Commitment to the Future of Medicare Act. These laws force patients to suffer in pain and even die as they wait for necessary care. I believe those who created or enforce such laws are responsible for the deaths of Canadians, and they belong in jail. Mind you, I also believe in the death penalty for the likes of Clifford Olson. So who can possibly believe it's wrong to be able to buy insurance against sickness when you're alive, but okay to buy insurance in case one dies? Who can justify the fact that an animal owner can legally buy health insurance for the pets they love, but not for the human relatives that they love almost as much? In Chowley, the majority applied ethical and moral and legal principles in determining that elected politicians do not have the right to override the freedoms that our parents and grandfathers fought for in 2 world wars. Politicians are rated by citizens among the sleaziest and least respected of all workers. It's our duty to challenge laws that they create when they are based on prejudice and false logic. I'm comforted by the fact that even among deans of the Osgoode Hall Law School, 2 of Lorne's predecessors as dean, Peter Hogg and Patrick Monaghan, who is currently the Deputy Attorney General here in Ontario, I believe, support my views. So you're outnumbered 2-1 in Dean's, Lorne. So how has the current status come about? We virtually canonized Tommy Douglas, who's been falsely credited with introducing Medicare in Canada. This man, voted by some CBC viewers as the greatest ever Canadian, believed and wrote his thesis on culling those he called subnormal, endorsing Hitler's philosophy on the issue. However, even he believed that we should pay premiums for health care. Our opponents are quick to provide so-called expert views on the topic of reform. Every single study they quote, and I mean everyone, is flawed and inaccurate. That is why we are anxious to have a judge review the evidence and facts rather than opinion. One of our strategies in court will be to dispel false information that has been replicated by numerous groups opposed to divorce, and to reform. And I include this slide because some of these issues were brought up this morning. But just because something is entrenched in a belief or in the literature does not mean it's true. And what happens is these beliefs become prejudices. So just as an example, there's nothing about Adam and Eve and an apple in the Bible. Jonah was not swallowed by a whale. There's no evidence clinically that the Hatter was mad. Sherlock Holmes never said elementary, my dear Watson, and so on and so on. King Wenceslas was only a duke. Nelson was not blind. Bats can see perfectly well. And Banting and Best did not discover penicillin. Even more sinister is James Bond. If you read Fleming's original work, he liked his martinis stirred, not shaken. So my point is, always check on your facts and data before you believe them. One of our strategies has been, therefore, as I said, to dispel myths. But another is thing we're faced with is government and trade union hired mercenaries who will present their opinions in court. These are called expert witnesses. Some of them are in denial of the fact that there's a sustainability problem caused by our aging population. By the way, the slide at the top is just to show the baby boomer generation. It's my school picture from 1958. I'm sitting on the front row, and sitting on the back, standing at the back row are Paul McCartney and George Harrison. Some of the denial about the costs of chronic disease and the aging population and increased technology. And essentially what we're doing here is we are mortgaging our future on the backs of our youth. Long wait lists in Canada are medically harmful and economically stupid. Canada is literally paying tens of billions of dollars in order to keep patients waiting. The Commonwealth Fund is a non-profit foundation that focuses on the issues that affect vulnerable and low-income Americans. In ranking 11 health systems in the developed world economies, Canada was next to last and the US was last. And there are many other studies around the world that come out with similar conclusions. A 2015 book by a British author, Mark Britnell, attempted to describe using 12 categories what a perfect health system would look like. 12 countries contributed to the list, and not one of in the list is Canada. This slide illustrates the arrogance of our opponents. Read the captions. Charles Wright is a contributor to Lorne and Colleen Flood's book. He was an expert witness in the Chowley case. His quote illustrates a disdain for patient rights. He actually admitted lying under oath in the Chowley case, in which he was, and I say this in quotes, an expert witness. Jonathan Lomas, a government-funded bureaucrat, endorsed Wright's view that citizens are too stupid to be trusted with looking after their own health. Surveys of doctors in Canada have revealed that 26% have had a patient die on a wait list. The Supreme Court of Canada in Charlie ruled that Canadians are suffering and dying on wait lists. This is a sad reflection on our situation. Data from around the world shows that we have an expensive and inefficient scheme by every measurable criterion. Studies using freedom of information access have shown that our system is inefficient, even when compared to US Medicare. False self-reporting of administrative costs in Canada was exposed by Dr. Barry Turchin in 2008. Our public system has 11 times as many public bureaucrats draining its resources as Germany does. Yet Germany has universal health care without wait lists. Does anyone really believe this is unrelated to the fact that German public health bureaucrats are exposed to competition? A group called Canadian Doctors for Medicare is intervening against us and our patients in our lawsuit. Their vice chair, Dr. Bob Woolard, presented false data in a debate he had with me before the whole class of UBC medical students. He showed on this slide that rising health costs were not a problem. His slide was a scam with a purposefully distorted horizontal access scale. It was designed to deceive. This is what the data really looked like when the horizontal scale was corrected to equal time increments. The following clip, near the end of our debate with between Woolard and myself, illustrates the contrast in perceptions of what each of us believes constitutes timely access to care. Google's a great thing, right? So yesterday when I found I was going to I realized, I should Google Dr. Woolard and see what he said about access and healthcare. And first thing came up was a quote. I was in the quote on the front page of the LA Times. So was Bob. Here's the quote when asked about the Canadian health system. Woolard said, "The public system has the nimbleness to provide speedy, quality care to those who truly need it. Just 6 or 8 weeks ago, I had a patient come in who needed urgent attention to her knee. She was in severe pain," he said. "She was seen by a reviewing team within a week, and she was slated for surgery that will probably happen in the next 2 to 3 months. That's 5 months in severe pain." Bob, that is not the health system that I aspire for in Canada. I think we can do a lot better. You can see how frozen he is throughout. Health economist Robert Evans' career has been based on the view that increased health costs were a result of too many doctors treating too many patients. Based on his advice, medical schools across the country were cut back. The result? Canada has a shortage of doctors. In the early 70s, when I came to Canada, we were ranked 4th in the world in the number of doctors per population. Today, we rank 26th, thanks to Dr. Evans and to the deputy ministers that endorsed his views. Canada does not have a comprehensive, universal, accessible, or portable system. Drugs, artificial limbs after amputations, ambulances after a heart attack are covered only for those with private insurance. The worst outcomes and the worst access in Canada are in the poorer and underprivileged classes. 70% of us have private, what I call two-tier insurance. The groups listed on the right are privileged and able to bypass Canadian discriminatory laws. We are fighting for the right of unjailed Canadians to have the same freedoms granted to those in jail.
You're on. There is a critical decision coming. And when the time comes, Dr. Day is confident a change is coming too.
If you support the status quo, then you are supporting a system that is killing patients. This is something the Supreme Court of Canada said, not Brian Day.
I'd like to point out that the government went to court in the recent assisted suicide trial to argue against the rights of dying patients to die without pain and suffering. In our trial, which is scheduled for June of this year, and it will be precedent-setting after it goes through the various levels of the courts, it will be precedent-setting for every province. In our trial, they will argue against the rights of living patients to live without pain and suffering. The final clip in my talk summarizes what will likely be a 4 to 5 month trial in one short minute.
There's a fundamental difference between forcing someone to pay. When we refer to the bad old days, when someone would be bankrupted by illness, that's because they were forced to pay when they became ill. But there's a fundamental difference between forcing someone to pay and allowing them to pay. And the thought we'd like to leave you on is, I think tomorrow you'll be hearing a case in which parents of autistic children were paying for a service that the government refused to provide. The government, I'm sure, will tell you that they have limited resources. This is probably what they'll tell you tomorrow. They have limited resources, and therefore they cannot provide them. But imagine the following scenario. Imagine the government decides to cover the service, but then affects so few resources to it that it won't be possible to have a 2-year waiting list to get in the program. And then imagine that you prohibit those parents from paying themselves if they want the service, even though it's not available. And then you have the facts of our case.
That simple statement sums up our case. And as Patrick Monahan, the previous dean of Osgoode Hall, has said, and Senator Kirby said, the government can't have it both ways. You can't promise access, not deliver it, and then outlaw a citizen's right to that access in a free and democratic society. Thank you.